Have you ever mailed something important and then just prayed it would arrive on time?
Every tax season. I dropped that envelope in the mailbox at 11:58 p.m. on April 15th and crossed my fingers.
Exactly. And the IRS counts your return as timely if you postmarked it by midnight on the deadline, even if they receive it 3 days later.
Thank goodness, because otherwise I'd owe penalties every single year.
Well, imagine if instead the IRS said, no, we need the actual physical envelope in our hands by midnight on April 15th. Postmark doesn't count. Mail delays, your problem.
That would completely change how millions of people file taxes.
That's basically what the Supreme Court considers on March 23rd, Watson versus Republican National Committee, whether federal law requires election officials to receive mail-in ballots by Election Day, or whether mailing them by Election Day counts as timely voting.
And nearly 30 states currently allow ballots postmarked by Election Day to arrive a few days later. If the Fifth Circuit ruling stands, all those laws disappear overnight.
Including laws that protect military voters who mail ballots from overseas.
Wait, military voters could lose their votes because of mail delays they can't control?
Potentially. And that brings us to the wild part. Federal law already allows military ballots to arrive up to 10 days after Election Day under a statute called UOCAVA, the Uniformed and Overseas Citizens Absentee Voting Act. Yet, the Republican National Committee argues that very same federal law, the Election Day statutes from 1845 and 1872, prohibit states from accepting civilian ballots that arrive 5 days late.
So military voters get 10 extra days, but civilian voters in Mississippi can't get 5?
That's the paradox the court needs to resolve.
Welcome back to the High Court Report. Jordan. Today, does the Constitution's Election Day requirement mean ballots must leave voters' hands by Election Day, or land in officials' hands by Election Day?
Quick reminder, please follow, rate, subscribe, share, and review to the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report.
And if you review us, make it 5 stars. We accept nothing less than A+ constitutional analysis.
Questions about this case? Reach out to us via LinkedIn at the High Court Report.
All right, here's what you need to know.
Here's the technical legal question: whether federal election day statutes preempt state laws that allow ballots voters cast by federal election day to arrive at and count when election officials receive them after that day.
Okay, translate that.
3 federal statutes set Election Day for Congress and the President as the Tuesday after the first Monday in November. The statutes say that's the day for the election. Mississippi allows mail-in ballots postmarked by that Tuesday to count if they arrive within 5 business days later. Republicans sued, claiming federal law requires both mailing and receiving by Election Day.
So the fight boils down to what the day for the election means.
Does election mean the moment voters drop ballots in the mailbox? Or does it mean the moment officials open the ballot box and start counting?
And the statutes themselves, what do they actually say?
Let me read you the key one. This comes from 2 U.S.C. Section 7. The Tuesday next after the first Monday in November, in every even-numbered year, establishes itself as the day for the election in each of the states and territories of the United States, of representatives and delegates to the Congress.
The day for the election, that phrase does all the work here.
Right, and Congress passed nearly identical language for Senate elections in 2 U.S.C. Section 1 back in 1913, and for presidential electors in 3 U.S.C. Section 1 way back in 1845. All 3 statutes use that same phrase, the day for the election.
Which brings us to the facts. What actually happened in Mississippi?
Mississippi Code Section 23-15-637 allows absentee voters to mail ballots and requires those ballots to bear a postmark on or before Election Day. Then officials count those ballots if they arrive within 5 business days after Election Day.
5 business days? So potentially a week or more?
Exactly. Mail a ballot on Tuesday the 5th, and it could arrive the following Tuesday the 12th and still count.
Who sued to stop this?
The Republican National Committee, the Mississippi Republican Party, 2 individual Mississippi voters named James Perry and Matthew Lamb, and later the Libertarian Party of Mississippi jumped in.
Republicans and Libertarians teaming up. That tells you something about the political stakes.
They filed in federal district court, arguing Mississippi's receipt deadline violates those federal election day statutes. 2 groups intervened to defend the law, Vet Voice Foundation and Mississippi Alliance for Retired Americans.
Organizations focused on military and older voters, people who rely heavily on mail-in voting.
Exactly. The district court sided with Mississippi Secretary of State Michael Watson, holding that election means voters' conclusive choice when they mark and mail ballots, not when officials receive them.
So the district judge said mailing by election day satisfies federal law.
Right. The judge reasoned that receiving and counting ballots happen after the election concludes. They're just administrative steps to effectuate the choice voters already made.
But the Fifth Circuit reversed.
Unanimously. A 3-judge panel, Judges James Ho, Kyle Duncan, and Stephen Higginson, held that the day for the election means the day officials must receive all ballots and close the ballot box, not just the day voters must mail them.
And the full Fifth Circuit refused to reconsider that decision?
Denied rehearing en banc, though 5 judges dissented from that denial. Judge Higginson, joined by Chief Judge Priscilla Richmond and Judges James Dennis, Carolyn Dineen King, and Dana Douglas, warned the decision would invalidate laws in nearly 30 states and disenfranchise military voters.
Which brings us to the Supreme Court.
The court granted cert in November 2025, and now we wait for oral argument to see how the justices approach this fight between states' power to run elections and Congress's power to set uniform federal rules. Let me walk through what Mississippi argues because Secretary of State Watson makes 3 main points that all build on each other.
Start with the definitional argument.
Watson says election means the voter's conclusive choice of officers, and voters make that choice by casting ballots, meaning marking and mailing them. He quotes the court's 1921 decision in Newberry v. United States, a major early case about congressional power over elections, defining election as the final choice of an officer by the duly qualified electors.
So under that definition, the election happens when voters act, not when bureaucrats process paperwork.
Exactly. And Watson points to Foster v. Love from 1997, where the court defined election as the act of choosing a person to fill an office, quoting Noah Webster's 1869 dictionary. He argues historical dictionaries from the 1800s consistently defined election as voters' choice, not officials' receipt.
What about precedent? Does the court distinguish between casting and receiving?
Watson leans heavily on Republican National Committee versus Democratic National Committee from 2020, decided per curiam, meaning the whole court agreed without individual justices signing opinions. In that case, the court recognized ballot casting as fundamental to elections, but never described ballot receipt that way.
So casting matters constitutionally, but receiving doesn't?
That's Watson's argument. He says receipt resembles counting. Both occur after voters cast ballots, both prove essential to effectuating voters' choices, yet everyone agrees counting lawfully happens after Election Day.
And if counting can happen after Election Day, why can't receiving?
Exactly his point. Watson argues that if election included receipt, it would logically include counting too, but nobody claims states must finish counting by midnight on Election Day.
What about the practical consequences? What does Watson say happens if the Fifth Circuit ruling stands?
He warns it would doom laws in nearly 30 states that currently accept ballots arriving after Election Day, including federal protections for military voters under UOCAVA, the Uniformed and Overseas Citizens Absentee Voting Act.
Break down that military voter point because it seems critical.
Congress passed UOCAVA, codified at 52 U.S.C. Section 20,302, specifically allowing states to count military ballots arriving up to 10 days after Election Day, as long as military voters transmitted those ballots by Election Day. Watson asks, if federal Election Day statutes already required Election Day receipt, why would Congress need to pass UOCAVA? The statute would directly conflict with the underlying requirement.
So UOCAVA only makes sense if the baseline rule allows post-Election Day receipt?
That's the argument. Watson also points to Civil War-era state laws letting Union soldiers vote absentee. Multiple states enacted those laws right after Congress passed the first federal Election Day statute in 1845, and Watson claims those laws prove states understood they could accept ballots after Election Day.
Did they actually?
That becomes a huge historical fight between the parties, which we'll get to. But Watson's broader point, if federal Election Day statutes prohibited all election innovation, we couldn't have secret ballots. Those replaced public oral voting in the 1890s. We couldn't have voting machines. We couldn't have early voting or absentee voting at all.
Because none of those existed when Congress set Election Day in 1845?
Right. Watson argues the Fifth Circuit's logic freezes election administration in 19th century practices, which makes no sense given how elections evolved over 165 years.
Okay, now flip to the Republican National Committee. What do they argue?
The RNC makes basically the mirror image argument. They say election refers to the state's public process of selecting officers, which concludes when officials close the ballot box, meaning when they receive the final ballots.
So the emphasis shifts from individual voters to state election systems?
Exactly. The RNC quotes period dictionaries too, but different entries. They cite the Century Dictionary from 1901 defining election as the act or process of choosing a person or persons for office by vote, emphasis on process, not individual choice.
And they say that process ends when the ballot box closes?
Right. They also emphasize the statutory context. Congress wrote these laws under the Elections Clause and Electors Clause, which regulate when states must hold elections. The statutes say things like, in each of the states, an election held in any state.
So Congress regulated state action, not individual voters' private choices.
That's the framing. And the RNC hammers on Mississippi's own regulations, specifically 01-17 Mississippi Code of Regulations, Section 2.3a, which treat mail ballots as final only after receipt, processing, and deposit into a secure ballot box, not when voters mail them.
Wait, so even Mississippi's rules contradict Watson's argument?
The RNC claims exactly that. They also point out that USPS rules allow voters to recall mailed ballots, meaning a ballot dropped in the mail on Election Day remains revocable for days afterward.
So if I mail my ballot Tuesday morning, I could theoretically call USPS Tuesday afternoon and say, never mind, I want it back?
Technically, yes, though the RNC admits that's become increasingly impractical. But their point stands. Mailing doesn't irrevocably finalize a vote the way depositing a ballot in an official ballot box does.
What about the historical argument? Because Watson and the RNC both claim history supports them.
This gets into serious detail. The RNC traces every single Civil War era absentee voting law for Union soldiers, and they argue every one of those laws required military officers serving as election judges to receive soldier ballots by Election Day, even though soldiers voted days or weeks earlier.
Give me an example.
Connecticut in 1864 sent commissioners to collect soldier ballots 40 days before Election Day, but the statute, the Act of July 7th, 1864, Chapter 37, required those commissioners to deliver the ballots to the ballot box on the day of the election. Minnesota did something similar under the Act of September 27, 1862. Soldiers gave ballots to a commissioner weeks early, but the law required deposit at the opening of the polls on Election Day.
So early voting existed, but late receipt didn't.
That's what the RNC claims. They argue states understood they could let soldiers vote early for practical reasons, but federal law still required someone to receive those ballots by Election Day itself.
What about Watson's argument that UOCAVA proves Congress accepts post-election day receipt?
The RNC says UOCAVA represents a narrow exception. Congress expressly enacted using its Elections Clause power to alter state regulations. They quote the constitutional text, Article 1, Section 4, Clause 1 gives Congress power to make or alter such regulations about congressional elections.
So Congress can create exceptions to its own rules?
Exactly. The RNC argues that if Congress wanted to authorize post-election day receipt for everyone, it would have passed legislation saying so, just like it did for military voters. The exception proves the rule.
And where does the United States come down in all this?
The Solicitor General filed an amicus brief supporting the RNC, which matters because the federal government typically stays neutral in state versus party fights unless federal interests get implicated.
What federal interest gets implicated here?
Uniform election administration and fraud prevention. The United States emphasizes that Congress enacted these Election Day statutes during an era of rampant ballot stuffing and fraud. The whole point of closing the ballot box on a single uniform day across all states, preventing late arriving fraudulent ballots.
Does the government bring anything new beyond what the RNC already argued?
Two things really stand out. First, they dig deep into congressional debates from 1844 when Congress passed the first Election Day statute. Representative Chilton explicitly said in the Congressional Globe that the law meant no votes cast after that day should be received.
So the legislators themselves understood receipt as the deadline?
According to this historical evidence, yes. Second, the United States lists specific state laws that already push the boundaries. 5 states, Alaska, D.C., Maryland, Illinois, and Washington, accept ballots arriving 10 to 21 days after Election Day, and 8 states, California, D.C., Illinois, Maryland, Nevada, New Jersey, New York, and Oregon, count late ballots even without postmarks proving Election Day mailing.
No postmarks? So you could theoretically mail a ballot a week after Election Day and claim you mailed it on time?
That's the concern the government raises. They argue Watson's theory can't distinguish those extreme practices from Mississippi's 5-day window, and it can't prevent states from going even further, like allowing voters to hand-deliver ballots weeks after Election Day as long as they attest they marked them on time.
That does sound problematic. What analogy does the government use?
They compare ballot receipt to making a check legally negotiable. Writing a check means nothing until the payee receives it. Similarly, marking a ballot means nothing legally until officials receive it.
And they distinguish receipt from counting?
Heavily, they say receipt makes votes legally effective, perfects them in the language from Maddox versus Board of State Canvassers, a 1944 Montana Supreme Court case, while counting merely ascertains what those perfected votes decided. Only the former must happen on election day. Okay, so what should we watch for when this gets argued?
I think the justices will absolutely hammer both sides on line drawing. If Watson wins and mailing counts as casting, what stops states from accepting ballots arriving 3 weeks late? If the RNC wins and officials must receive ballots by election day, what happens to military voters overseas?
That military voter question seems huge. I can't imagine any justice wants to rule in a way that disenfranchises troops serving abroad.
Right? But Watson and the RNC have totally opposite explanations for how UOCAVA fits in. Watson says UOCAVA proves the baseline rule allows post-election day receipt. The RNC says UOCAVA creates a narrow exception to a baseline rule requiring election day receipt.
Expect justices to really press both sides on statutory interpretation method. Do you read these 19th century statutes based on original public meaning, or do you let them evolve with changing election practices?
And I think we'll hear a lot about the Postal Service. Does handing a ballot to a mail carrier count as giving it to the government? Or does the Postal Service function more like FedEx, just a delivery service?
That distinction matters enormously, because if USPS doesn't count as state custody, then even mailing by election day might not satisfy federal law under the RNC's theory.
What about the textualist justices? How do they approach a phrase like the day for the election when both sides cite dictionaries supporting their view?
Good question. I think they'll look hard at statutory context. Who does Congress address in these statutes? The statutes say, in each of the states, an election held in any state, which suggests Congress regulated state action, not individual voters.
But Watson does make that strong textual point about counting. If election includes receipt, why doesn't it include counting? And everyone agrees counting happens after election day.
The RNC and the government draw that line by saying receipt perfects a vote legally while counting just ascertains results. But I think justices might push back. Why does that distinction appear nowhere in the statutory text?
And practically, how do courts even enforce an election day receipt deadline during a pandemic or natural disaster when mail gets delayed?
Watson raises exactly that concern. He warns that an election day receipt rule would disenfranchise voters who did everything right, mailed ballots on time, but whose ballots arrive late due to circumstances beyond their control.
Although the RNC would say, then those voters should vote early or vote in person. The law gives them options.
True. I also think we'll hear questions about whether this fight even belongs in federal court. The district court found that the political party committees suffered organizational injuries. The Supreme Court just decided Bost versus Illinois State Board of Elections in 2026, which clarified the standing requirements in election cases for people running for office.
Could the court dodge the merits entirely on standing grounds?
Possibly, though I doubt it. The cert grant suggests at least 4 justices think this question needs resolving, especially given how many states it affects. And, as we just mentioned, in Bost, the court just answered a standing question involving the same ultimate question as here, whether states can accept ballots after Election Day.
Bottom line, time. Why does this case matter?
Because it determines whether federal Election Day statutes from the 1800s lock states into election administration practices from that era, or whether states can adapt voting procedures to accommodate modern realities like mail delays and absentee voting.
And practically, it decides whether nearly 30 states need to rewrite their election laws before the next federal election,
including whether millions of military and overseas voters lose the extended receipt deadlines that currently protect them.
We'll have full coverage right after oral arguments and again when the court decides. This one matters for everyone who votes by mail.
If you made it this far, share this episode with one person who doesn't think Supreme Court cases affect their daily life.
Because this case literally determines whether their vote counts if the mail runs slow.
Please follow, rate, subscribe, share, and review to the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report.
And please review us. We need those 5 stars like Mississippi needs ballot receipt clarity. Talk to you soon.